Hello, folks. Welcome to this session of Caring for the Caregiver, a monthly webinar series. I will let folks trickle in right now as I see the numbers going up very strongly. This is the session on estate planning, but I'll let folks come in, and once those numbers stop, I'll introduce myself and tell you a little bit about what's going on today. For the new folks coming in, hello again. Welcome to this lunchtime session on estate planning with NAELA, EOEA, and the Office of Economic Empowerment. We'll start shortly as those numbers keep growing. Welcome all. We'll start most likely in a minute. Okay, it looks like our numbers have slowed. We'll still let people trickle in as I'm giving this introduction here. So again, welcome to this session on Caring for the Caregiver, a monthly webinar series for part 1 of our webinar series. This session is on estate planning. My name is Jessica Keegan. I use she, her pronouns. I'm coming with you from the Office of Economic Empowerment. If you haven't heard of us, that's okay. We are a department of the Massachusetts Treasurer. And our 3 main goals are creating a bright future for children across the state, closing the gender and racial wealth gap, and of course, providing free and accessible financial education. So today we've connected with the National Association of Elder Law Attorneys with Abigail, and of course with the Executive Office of Elder Affairs with Molly, who's here in the chat, to give you this webinar on estate planning with next month's session on probate. So I'll go over a little bit of housekeeping while folks trickle in. I wanted to mention that this is a Zoom webinar, so it will be recorded, and the recording will be uploaded to, may be uploaded to a public website for future use. Any information shared through the question functions will be anonymous, but please note that the chat record is subject to public record laws, and as such is not anonymous. You may have noticed that this is a webinar and not a meeting. As such, you will not be able to view the other participants, but feel free to message us in the chat, and Q&A will be available throughout the webinar. I'll also mention, I know we're at the beginning here, but the moment you click exit, a little bit of a post survey will pop up, so please fill that out so we know how we can continue to improve this program. I will also mention that I will turn on the transcription feature in just a moment. And if you have any questions with captioning, just let us know. And I will turn it over to Abigail in one moment, again from the Massachusetts chapter of the National Association of Elder Law Attorneys, also known as MassNAELA. And then, of course, we'll also have time for questions at the end if you have any now. Okay, I'll switch over to Abigail. Thank you so much.
Great. Thank you very much, Jessica. And I'm so happy to be here with everybody to talk about some estate plan documents to have in place. So thank you for joining us today. So where I wanted to start was with a little bit of housekeeping myself. So keep in mind that this presentation isn't providing any sort of legal advice or creating any sort of client-attorney relationship. And then also, really, one size does not fit all. And what I mean by that is that although I'm going to talk about some basic estate plan documents to have in place, your estate plan might look very different from your neighbor's estate plan. And that's all because your estate plan should be tailored to suit your goals and needs, your family dynamics, and your finances. On top of one size does not fit all for estate plans, that's the same is true for attorneys. So I'm talking again generally, and that every attorney does things differently. So they may have some slightly different forms, they may strategize or do an estate plan differently as well. So one attorney is not always the same as the next attorney. And I invite you to certainly look for an attorney that is a good fit for you at the end of the day. So with that being said, let's jump into some of the documents that would be good to have in place as part of an estate plan. So, and just to provide some framework here, the way I'm going to be talking about this today is that I'm looking at this from the lens of a caregiver and the person that they're providing care for. So the person that you are caring for is the person that's really going to be completing these documents to give you as the caregiver the legal authority to make decisions for them, healthcare and financial decisions for them while they're alive. In particular, the documents that do that are the power of attorney and healthcare proxy. So that's what I want to start with. And these documents really come into play again, when somebody is alive, but they may not be able to make those decisions themselves anymore. They're what we call incapacitated. So a power of attorney is a form. It's a particular document. It's called a durable power of attorney that names somebody called an attorney in fact to make financial decisions for the person you're taking care of. So typically, oftentimes the caregiver is the person who is named in the person the power of attorney of the person they are caring for. So the caregiver is appointed under this document as the attorney in fact. That's what that position is called. And usually you want to have at least one person named. The person you're caring for wants to have one person named as the primary attorney in fact. And then you also want to have a backup to that attorney in fact, that primary person. So you want to have an alternate attorney in fact. So what does the power of attorney do? So they can do a couple of different things. What they can do generally is that they get legal authority. So the person you're caring for using this document gives you, caregiver, as attorney in fact, the legal authority to make financial decisions on their behalf and also to access financial accounts. So for example, if the person you're caring for needs your assistance, the attorney in fact's assistance with paying bills, then the attorney in fact can use this document to go to the bank, access that person's bank account, and then start paying bills on their behalf. Beyond that, they have a number of other types of powers. So they can do things like sell homes or mortgage home. They can file personal income tax returns for the person they're caring for, if they're the attorney in fact under the power of attorney. They can also do things like designate beneficiaries on retirement accounts or investment accounts or bank accounts. They can also apply for public benefits. So as you can see, it's not just about accessing financial accounts. It's also about making financial decisions. So there's a lot of power that comes with these documents, and it's incredibly helpful to have if you have a person who's alive again, but cannot do this for themselves anymore. So let's also talk about the next document here. The next document is called the healthcare proxy. The healthcare proxy appoints somebody called a healthcare agent to make healthcare decisions for that person. So in this particular situation, if you're the person you're caring for would complete a healthcare proxy document that would name you as the caregiver as the healthcare agent to make healthcare decisions for that person. So what you as the healthcare agent need to do is that you're thinking about if it's a situation where you're making a healthcare decision, for the person you're caring for, you're thinking about what that person's wishes are, what their religious beliefs are, or moral beliefs. You're also consulting with the care providers. So that might be a physician. And you're also considering what kind of wishes might be out there with regards to end of life care or things along those lines. So with all of that in mind, you as the healthcare agent are making a decision on behalf of the person that you're caring for. So again, like the power of attorney, you want to always have one primary healthcare agent named and then have at least one backup. And the reason that I typically suggest that is that something might happen to you, caregiver. Maybe you have your own family emergency and cannot step in and continue to help the person you're caring for. So having a backup in place is thinking down the line. It's thinking about the future in case something happens to you, as well as the person that you're caring for. The healthcare proxy is a standardized form in Massachusetts. So it may be a form that you've actually completed at your doctor's office, or if you went to the hospital, they might have had you fill one out while you were there if you were awake and capable of doing so. And usually it is signed in front of two adult disinterested witnesses. And what I mean by that is it's usually, it can't be the people that you have named as agents. So it may be done at the hospital, it may be done at your doctor's office. If you are not sure, it's always a good idea to check. And the reason I mention that is that if you sign a new one, then it basically voids or cancels the old one. So keep that in mind. Maybe it's time for you to sign a new one and you do want to confirm that that has been taken care of. And it's the other part of this is not just signing the document, it's also sharing that document with the people who need to have it. So you want to share the most up-to-date healthcare proxy with your doctor. So it's part of your medical records, and also share a copy with each of your healthcare agents. So if they're running out the door because there's been an emergency, then you want to make sure you, caregiver, have a copy of the most recent healthcare proxy that appoints you as healthcare agent, so that if you get to the hospital at this emergency, then the doctors don't have a record, you can share it with them, and then you can start making those necessary decisions on behalf of the person that you're caring for. So healthcare proxies, as I said, it's a standardized form, and there's actually a few different websites online that provide more information about them. One is actually MassNAELA. Our website does have a page, it has multiple language that talks about languages about the healthcare proxy and how to complete it. And there's also a website called Honoring Choices, MA, where they provide a toolkit that you can download and it walks you through completing the healthcare proxy. It gives you the healthcare proxy and tells you how to complete it on your own. A lot of attorneys, if you're seeing a private attorney, will actually have a healthcare proxy that they have provided or included expanded powers to make it clear about what your healthcare agent can and cannot do, instead of relying on statute or case law to make that decision for you or to provide that guidance. So that's it for the healthcare proxy. I think one of the important things to discuss is what happens if you don't have these documents in place. So you want to make sure that there's the person you're caring for, as the caregiver, you want to make sure that you have the legal authority to do these things, to make these financial decisions, to make these healthcare decisions. And so one way you do that is that you can be proactive and prepare a power of attorney and a healthcare proxy, as long as the person you're caring for is competent and can sign these documents. If they're not competent or the documents aren't prepared, then that's okay. There's laws in place and a procedure in place with the probate court to give you that legal authority. And so that's called a conservatorship and a guardianship. So in Massachusetts, we have a bifurcated system. And what that means is that you can be appointed as the conservator to manage the money of the person that you're taking care of, and or you can be appointed as the guardian to make healthcare decisions for the person that you're taking care of as well. So typically what that includes is petitioning the court to be appointed. It does take some time. You can do a more immediate temporary version, and then also a more permanent version of both of those positions. Typically, there is court supervision or oversight of these things, and some of this information is public records, and it can cost additional money. So again, if you're in a position, caregiver, where you are caring for somebody who is competent and understands and can sign legal documents, to be proactive and avoid going through the probate through this court process as much as you can, then you can certainly do the power of attorney to essentially replace, or in the stead of a conservatorship, or the healthcare proxy instead of, or in place of, essentially a guardianship. So one form that I just want to mention is a HIPAA authorization form. And again, this is a form the person you're caring for may have completed at the doctor's office or at the hospital, but they also may not have. So the HIPAA is a federal law, and it basically says that medical care providers like doctors and hospitals are not allowed to share medical information unless the person who has that medical information, they give permission and consent. So the way that you can do that is you can simply list the names of the individuals that you would feel comfortable with calling the hospital, and the hospital sharing how you're doing after a surgery, for example, with that individual, or gathering medical records for you. So it's not just it's not somebody who's making healthcare decisions. It is a person who is gathering medical information or records. And so it can be more people than your healthcare agent. So if you have family members or friends that you would want to know about how you're doing medically or healthcare wise, then this is the form where you would include them beyond the healthcare proxy. It would give them the ability to get information about you. They wouldn't be making any decisions for you, however. So I want to switch gears after talking about that and discuss a last will and testament. So this is the kind of the last don't leave home without it estate plan document that I want to touch on today. And that document, as I said, is the last will and testament, and it is different from the others. So the others, really, the power of attorney and the healthcare proxy, again, those are documents that are essentially alive when the person you're caring for is alive. So meaning that the power of attorney is, for example, going back to that example I gave a little bit earlier, if you're serving as the attorney in fact under the power of attorney for somebody, the person you're caring for, you go to the bank, you show them the power of attorney document, typically the original or a certified copy, and they say, okay, we're going to add you onto the current account, and you'll sign checks as the attorney in fact for that person. When that person, the person you're caring for, passes away, the power of attorney is no longer valid. It can't be used. So what that means in essence is that you cannot continue to use those funds, access that bank account, and pay expenses at that point because the power of attorney is no longer valid because the person has passed away. So the last will and testament is the document that says what happens to that bank account, what happens to any other assets of a person after they pass away. It's essentially instructions that are put in writing that say how the person you're taking care of or caring for after they pass away, how their assets are distributed out. And the person who manages that distribution of assets, accessing and distributing those assets, is called the personal representative. They used to be known as an executor. They still are in other states. Massachusetts adopted laws in 2012 that changed the terminology there. So executor, personal representative, same thing. So the personal representative, again, that's the person who's the manager of the estate. They have the responsibilities of accessing, of filing documents with the court to be appointed, to then have the legal authority to access, consolidate, and then distribute out your assets. Assets like your home, your bank accounts, investment accounts, tangible personal property, which is your stuff like furniture and clothing and artwork and jewelry. And so typically the last will and testament is the document that says how those assets go through, must be distributed out, must be taken care of, and it usually needs to go through probate. And I'm going to talk about probate in our next webinar. So that's happening in September. So I'll go into a lot more detail about probate at that time. If you do not have a last will and testament in place, maybe you didn't get a chance, the person you're caring for is at the point where they are not competent anymore to be able to understand and sign legal documents like a last will and testament, then have no fear. Massachusetts does have what are called intestacy laws in place. And these are the laws that say, I don't have a last will and testament. Massachusetts state statutes, you get to say how my assets are distributed out, typically to family in many cases. If there's not family or blood relatives, then the statutes also say what happened in that kind of situation too. So there are, again, these laws out there that say, if there is no last will and testament, this is how those assets get distributed out after I pass away. If you want to have some sort of control over your how your assets are distributed, the person, or I should say, if the person you're caring for wants to have some sort of control over how their assets are to be distributed, then a last will and testament is the document that they would prepare to do that. So the last slide here is, that's great information, Abby. What do I need to do? How can I get the process started, right? So the first thing that you can do as a caregiver is start the conversation. Sometimes folks just haven't thought about who's going to pay their bills for them, or do they have the legal, do you as the caregiver have the legal authority? Not just, I've said that you can do this, but there's documentation in place that carries weight, that says that you as the caregiver have the authority to be able to pay bills. So asking, who's going to pay your bills for you if you can't do it anymore while you're alive? The same thing for making healthcare decisions. Asking, who do you want to make healthcare decisions for you if you're alive and can't do it for yourself anymore? Another good way to kind of start the conversation is, what are your thoughts? What have you thought about with regards to if something happens to you, if you pass away, how you want your money and your family heirlooms to be distributed? Another thing that you can always do is that you can provide more information and resources to the person you're caring for. You can reach out to your town senior center or council on aging, and they oftentimes have local attorneys who are coming in and giving presentations that are in more depth, or they have great resources that they can share with you. You can also reach out to legal aid services. Sometimes they have more information available, and they also can give recommendations on and potentially assist you with preparing some of these documents, especially if you don't have funds in place or sufficient funds to be able to pay for a private attorney to assist you. You can also visit our MassNAELA website, of course, for more information. And then kind of that final step there is, after you've had conversations and gotten more information, is to, of course, arrange a consultation with an attorney to begin that process. That might be with the legal aid attorney, legal aid services attorney, or it might be with a private attorney. And then see if you need to arrange transportation depending on the mobility of the person that you're caring for. Some attorneys, private attorneys, do visit homes if mobility is a concern or an issue. And then, of course, actually completing those documents. And the next important step is, of course, providing documents that are signed and completed to the relevant people, like that healthcare proxy, and making sure that the healthcare agent gets that document so that they have it and can show that they have that legal authority to make decisions. So that was it for me. I think that we're at questions and answers time. So I was going to invite Molly and Jessica to rejoin and see what kind of questions we have out there.
Thank you, Abby. Hello, everyone. Thank you for the very thoughtful questions. We've been getting lots of questions in the chat, in the Q&A. So I think we can just get started.
Yeah, great.
Okay, so the first question we got was, if there's already a power of attorney and a healthcare proxy, can alternates be added after a person is incapacitated without a legal process?
So the person you're caring for, it's their document. They need to be competent and understand the document they are signing. To shortly answer that question, typically no. You typically need to, the person has to be competent. They need to be able to understand and then sign those documents. So you would, in essence, need to do an entirely new document, typically, an updated power of attorney and healthcare proxy to add new people. That's why I suggest always make sure that you've got at least one backup in place, so you're thinking and planning for the future in case something changes with you as the current caregiver and you can't serve or don't want to serve in those roles anymore.
The next question we got in the Q&A was, what if my older parent is still making financial decisions? When do we name and implement the power of attorney?
So that depends on the power of attorney. There's two different types of powers of attorney. There's one called a springing power of attorney. The springing power of attorney is only activated when a doctor or physician says that your parent is incapacitated and can no longer handle managing their own financial decisions. Another type of power of attorney is called a non-springing power of attorney. The non-springing power of attorney is effective immediately. So that is, I would suggest looking at the terms of the document itself to determine what your next steps are going to be in that situation. Beyond that, it may be something where it's time to have a conversation about financial decisions and who can be involved in making those financial decisions. One of the things to always be thoughtful about is not only the capacity of a parent and maybe getting some sort of medical support or getting some medical information about whether they are competent or not at this point to handle their finances. And you're being very delicate about family dynamics as well in addressing whether or not a power of attorney can be used. So as you can tell, there's a lot of things that you have to think about when you want to start to help parent out, in addition to working and talking with them. So my suggestion is to see if you can open a conversation about these things with the person you're caring for, your parent, if there's other family members who are around or involved, and then also with the doctor to see how to proceed and proceed carefully.
So Abby, along those lines, for someone whose older parent is concerned that signing these docs will take away their ability to make their own decisions, autonomy, and give up control of their assets, to what extent is this true? And when does it make sense to fill out these forms, but let their parent or spouse, loved one, keep their own control?
Yeah. So again, that certainly is a concern that I've had clients who express that. And hopefully the person you're caring for is not naming people in those roles that they don't trust. These are people that you as a caregiver, they're placing a lot of trust in your hands to make healthcare and financial decisions for them. And so with that in mind, because it's their documents, keep in mind, these are the person you're caring for, it's their documents, it's their decision at the end of the day. And so hopefully they are thinking about who they'd want, who they trust to manage their funds for them, and if they can't do it themselves. So again, you're treading lightly in these kind of situations. You're thinking about the impact that you as a caregiver may have in taking on more of the responsibilities for managing finances for the person you're caring for. Keep in mind that when you are serving as an attorney in fact under a power of attorney, you have what's called a fiduciary obligation. It is your responsibility under the law to manage the funds for the person you're caring for. And there have been, as some people are well aware of, in the last few years, there's been conversations about celebrities who have people named as in conservatorships and not being happy with how their funds are being managed. And so you're thinking as the caregiver, that's when you have that responsibility. As attorney in fact, you are managing these funds for the time period that is necessary because the person you're taking care of can't do it. They may be able to do it again. And in that kind of situation, you're actually reporting to them. You're doing what's called an accounting. You're showing them all the work that you did, how you manage their funds when they become competent again. If they are incompetent and then pass away, technically, you also, as the attorney in fact under the power of attorney, have to account to the estate of the person who has passed away, showing how you have managed those funds. So I hope I answered that question well enough there. I didn't quite touch on everything.
No, that was great. Thank you.
Okay, great. Thank you.
And just as you were talking, we received lots more questions. So this is definitely helpful for a lot of caregivers on the call. So
sure.
All right. Another question that came in: can you have two primary power of attorneys, or I guess can two of these forms be in place at a time, or must it be primary and alternate?
Yeah, great question. So you can have joint attorneys in fact, or co-attorneys in fact. I've had clients who have named 2 or 3 children to serve together. However, I caution that. And the reason is that I have started encountering financial institutions like banks not being comfortable with pushing back on having 2 people named to be able to access accounts in that kind of regard. So typically what I'm suggesting to folks is it's better to have one person at a time in dealing with, especially as an attorney in fact under a power of attorney, and actually as a personal representative executor under the last will and testament. Not because you can't do it, but because we're encountering these additional obstacles that make it difficult for you as the caregiver to do your job. So if we don't need to have that obstacle, why put it in place?
That makes sense.
Mm-hmm.
The next question is, where do you go to appoint power of attorney?
Great question. So typically, you need to do a durable power of attorney document. And in that document, it says, I, Abigail Poole, appoint, Jane Doe to serve as my attorney in fact. And if Jane Doe can't serve, I'm going to appoint John Smith. So you go to an attorney typically to prepare that document. And again, you can visit a private attorney. I would suggest contacting your local senior center might have referrals for that. There's other resources that can give you names of estate planning elder law attorneys in your area. Or you can also go to legal aid services for your region. And there's multiple different services out there that have attorneys who can assist with preparing that document and getting that document executed.
Great, thanks, Abby. And I know we're going to send a follow-up email to everyone who's on the webinar with some of those ideas for resources in the community. Next question is, can a last will and testament be set up if a family member has some mild cognition impairment?
Ooh, yeah. So there's a long answer to a short question. So, but I'll try to keep it as short as possible. So it depends on the capacity of the person. And that is something where the person has to understand what their assets are. They need to be able to understand who those assets are going to. And they need to have be lucid at the time that these decisions are essentially made and the document is signed. So it's a sliding scale in many situations and dependent on many factors. And so my suggestion would be that you speak with an attorney. If the person has not been deemed incompetent by a doctor, usually what I do is if I have somebody approach me with a question, can we do a will? We're not quite sure about competency here, then I, as the attorney, can speak with and assess and determine whether or not from a legal perspective, whether or not that person has the competency to sign a legal document. And I've had situations where I've had to say, I'm sorry, we can't move forward in this particular case because the competency that I am assessing at this time is not there.
So Abby, along those lines, someone wrote in and said that when they completed estate planning a few years ago, their husband had mild cognitive impairment and now he has Alzheimer's. Do they need to redo all of the forms, given that their son is the alternate on the paperwork?
So I think that I would suggest if you got your estate plan documents done a few years ago, that you revisit your estate planning attorney and have them work with you to determine whether or not he has if estate plan document updates are necessary and to what extent they can be updated based on his current status, cognition wise.
What if someone is not acting in the best interest of the care recipient or the older adult, and they change their mind about a proxy decision after that power of attorney has been filed? Can the person change their mind about who their power of attorney is?
Yeah. So I just want to clarify with language.
Or who is on the power of attorney.
Yeah. So a power of attorney is different from a healthcare proxy. So in Massachusetts, a healthcare proxy only springs to life if the person has been determined to be incapacitated, unable to make healthcare decisions for themselves. Even with that being said, the healthcare age or the person who the healthcare proxy is made for they still have the ability to verbally revoke the healthcare proxy. So they still have that ultimate say with regards to healthcare proxy. Power of attorney, again, it depends on the language of the power of attorney with regards to what extent things can be revoked or invalidated, or even if it's active. So those are some of the things that need to be looked at. And then also to get a bigger, more comprehensive picture of exactly what's going on. Is there some concern about elder abuse? Should it be reported? What's happening that perhaps you disagree with versus what the caregiver is doing? Are there any other instructions, guidelines that the person who's being cared for left with regards to these things? So again, it's at a place where I would suggest really it's so specific that you would want to consult with an attorney to help guide you through that process and to see what's possible.
Thank you, Abby.
Mhm.
Learning a lot through this as well. So the next set of questions folks have asked us about the interaction with doctors, hospitals. So the first is, if the doctor or hospital has signed the healthcare proxy, can one assume that they're sending the form to one another? Let's say the PCP to the hospital, vice versa.
Oh, good question. Yeah. So I would not assume anything. So so what I would say is, for example, I am aware because I've had that visit to the hospital after visiting my primary care physician, that that information is all contained electronically on the same system. So I know that mine was shared with the hospital I go to and also with my physician. So I know I'm all set, but I wouldn't assume that. So I would always ask, I would say, has this been shared with the hospital? Is it part of the greater database that you have and system? Will they see this or not? And if not, how do I get this information to who I want to have it? Again, you can always go back to making sure your healthcare agents have a copy of your healthcare proxy too. And you can do that, not just giving them a physical paper copy, but scan it in so that they can save it either on their smartphone or save it in their email or in some document sharing program so they can pull it up electronically, which most people have their phones on them when they're running out the door in an emergency. They may not stop and think to grab the healthcare proxy in the filing cabinet in the back room, right? So that's why having it stored electronically and making sure your agents have it, not just the doctors in the hospital, are a good idea.
That's great advice. Thanks, Abby. Next question is, let's say a loved one has an accident overseas. Can the healthcare proxy be seen as valid in other places?
Good question. I don't know the answer to that. So, and I'm not afraid to say that. So I'm not sure. I would hope that it would be recognized in another country. But that is really something that I would quite frankly suggest that you reach out to an attorney in a state. There are actually estate planning attorneys who specialize in dealing more in an international law realm, and double check with somebody who has that kind of knowledge.
Great suggestion. This will be our last question because I think we're coming up on time. And it hints at what we're going to talk about next month. Is there a way to avoid the will going to probate by putting assets into a trust? If so, what assets can you put into a trust? And what are the pros and cons of probate and trusts?
Yeah, so Molly's got it. So that's something that we're going to talk about at our next webinar. So I certainly invite you to join that in September. So a short answer is yes, you can avoid probate. A number of assets can go into a trust. A trust is a fantastic tool. I love it. And it can do a lot of different things. I look at it as a multi-use tool. So we can talk about not only, I can include that as part of the conversation very quickly. There are so many different types of trust, and they do so many different things that it could be a week-long webinar. But what I'll do is I'll keep it to kind of one of the basic types of trust called a revocable trust, and how that interacts with probate and avoiding probate, and what kind of assets typically can go into a revocable trust.
Amazing. I love that we have this great plug for next session. I'm excited as well. Like Molly was saying, I'm also learning a lot here. I know that we just hit our last question. So as a reminder, when you hit the exit button on this, you'll be taken to an exit survey, and you'll be able to ask any questions that you may not have gotten to today. So if you do have more questions, there is a vehicle to receive them.
Great. Thank you very much.
Thank you, Jessica. Thanks, Abby. And thanks everyone for joining. I put the link to register for our next webinar in the chat. Please fill out that survey to let us know if you have additional questions, what you want to hear about next time, and also future webinars. We want to know what topics are of interest. And one last thing I'm putting in the chat, our masscaregiver@mass.gov, our general email address for this webinar series. If you have ideas beyond the survey or questions, comments, we want to hear from you. So thank you for joining. Have a wonderful rest of your day, and we will see all of you in September. Thank you.